J'ai un point d'ordre, Madame la Présidente.
Just hold on here.
On a point of order, Madam.
Un moment, s'il vous plaît.
Just one moment, please.
I called the meeting to order. Welcome, colleagues. This is meeting number 88 of the House of Commons Standing Committee on Justice and Human Rights. We are here today to continue our study of Bill C-40, an act to amend the criminal code to make consequential amendments to other acts and to repeal a regulation, miscarriage of justice reviews. I think you all know the rules by now, but happy to read them at some point if need be. And with us today, we have two witnesses from the Department of Justice. Madame Julie Besner, avocate conseil, secteur du droit public.
Julie Besner, Legislative Services, and Miss Shannon Davis, General Counsel, Acting General Counsel.
Start the clause by clause, but before I do, I will recognize Monsieur Fortin.
Thank you, Madam Chair. I'd just like to mention that we received notices of motion for 2 meetings that are to be held tomorrow. So we're not respecting the procedural rules that says we need 48 hours notice. So I would ask you to please take a look at these notices of meeting. Yes, but tomorrow I don't think that having a meeting tomorrow is in compliance with the rules. Thank you for your point of order. Mr. Caputo.
Thank you, Madam Chair. And first off, before we really get going, I know that our two lawyers and legal experts are here. Obviously, we welcome them. These obviously sometimes cannot be the easiest of times to sit there and watch Parliament. So we do thank you for being here and exercising such patience and diligence to kind of be ready at a moment's notice. So first and foremost, I do want to say that. Now, Madam Chair, my recollection is that we were to have the minister here. We don't have the minister here, and I'm inquiring as to how and why that occurred.
Because of you.
Okay. Fabulous. Thank you. I will respond to that.
Point of order, Chair.
Okay. So what we're going to do is...
Point of order.
So would you like me to take all points of order and make notes and then respond to all of them? Let's do that. Mr. Brock.
Yeah, I think in this particular case, it's probably very appropriate. Of all the committees I have sat on, and I have sat on plenty, not as a permanent member, but certainly floating from time to time, depending on what the issue is. But I can tell you something, and I think it's a testament to not only your chairing abilities, but our previous chair, Mr. Sarai, is that we generally are a collegial group, and we get the job done. More importantly, we are respectful of each other. We have disagreed rather strenuously on pieces of legislation and on points of order. But at the end of the day, and I think to all the lawyers sitting at this table, particularly Mr. Mendocino and Mr. Maloney, myself, Mr. Caputo, Mr. Van Popta. Oh, sorry, Mr. Housefather. My apologies, Mr. Housefather. I didn't know your background.
Eminent litigator.
And Monsieur Fortin. Oh, and
You've named everyone else.
I'm sorry. My God. I'm in the doghouse.
Our chair as well.
Again, please.
Okay.
I'm going to insist you start that again.
I think I have to start
because
again.
that's not respectful, and I know you didn't mean it that way.
I absolutely
So please
did
start
not,
again.
and I thank you. I thank you for the ability to correct various obvious faux pas on my part. With a very minor exception, everyone that sits on this committee do have law degrees, and I'm aware of that. But I'm particularly talking to those individuals who've had litigation experience. And I don't know about Mr. Housefather's background, but Mr. Maloney certainly did, Mr. Mendocino certainly did, Mr. Moore did, myself, Mr. Caputo, and I believe Monsieur Fortin had litigation experience. And the reason I'm suggesting that we go down this path very momentarily is that when you are in a litigation environment, whether that's a tribunal, whether that's a committee room, whether that's a courtroom, you fight like gladiators. You're advancing your position. In my case, it was advancing the interests of the state, representing the Crown. Mr. Mendocino did the same thing on behalf of the Department of Justice. But then you leave the courtroom and you are collegial with your opposing counsel, and you shake hands, you may engage in a discussion, you may have coffee, etc. And I like to believe that my experience, as limited as it has been since my election in September of 2021, has been a very positive experience, particularly on justice. Justice is primarily my home in terms of my committee work, and I've always felt a warmth, a generosity, a kinship with all the members of this particular committee. And as I said, we may disagree, but we walk out of this room just like in a courtroom, and we're collegial with each other. And the reason I'm bringing this to the chair's attention is I'm prepared to give Mr. Garrison the benefit of the doubt on this, because I do respect Mr. Garrison, but I did not appreciate the outburst that he displayed, and it was directed towards my colleague, Mr. Caputo, inferring that we are to blame for the sudden notice of meeting that was delivered in our inboxes. So I'd ask Mr. Garrison perhaps to reflect upon that. And if it was delivered with some degree of malice or intent, I think it's disrespectful. I think it's unparliamentary, and I would be asking for an apology and a retraction. Thank you.
Any other points of order, please? My God, I'm going to say this. This is not a good sign. Everybody in front of me is gentlemen. Any other points of order around the table, gentlemen?
Sorry, Mr. Brock had made his point of order. Madam Chair, you're the chair. You have the ability to chair the meeting as you see fit, and I'm not trying to usurp that or take that away. How I would hope that we could do this is as follows. What I would propose is I've asked a question on a point of order. If you're sure you're prepared to answer that question, I may have follow-ups, and then we can just go from there. And my hope is that we can just have a civilized discussion. We don't have the minister here. The question I have is why.
All right. Are you all ready to hear my responses without interruption?
Certainly, I may have a
Fabulous.
follow-up question after, but you go ahead uninterrupted, of course.
We had started with Bill C-40. That was what we were reviewing. We did not conclude that. My role as chair is to call meetings, set a number of administrative tasks. So within my role, I decided to continue with what we had not yet started, which was C-40, which we came back to last meeting. We didn't do that either last meeting because I think, and to be fair to Mr. Garrison, my recollection of last meeting, and I believe it went on for over 2 hours, was that members of the Conservative Party had a number of things to address. And we started to address them. Not sure if they're finished or not. And so I am allowing a lot of time to ensure that members of the Conservative Party and anyone else who wishes to have plenty of time to address those, which is why, in the capacity as chair, and I can give you the page number if you like, which I know you will like, so I have it ready. I I specifically scheduled meetings tomorrow just to give enough time to ensure that the Conservative Party members have enough time to address whatever points they would like to address in the hope of concluding clause by clause C40, which my recollection is all the parties in the room have pretty much come to an agreement on. But that would be the end result of my meetings right now, is to ensure that at least, at minimum, I get the clause by clause done so that we can deal with other matters that were scheduled. And we started a speaking order. Thank you, Mr. Clerk, for writing it down. And I believe Mr. Moore is on that list. So, Mr. Moore, over
Madame la
to you.
Présidente, vous n'avez pas statué sur mon point.
You didn't rule on my point of order, Madam Chair. Could you please decide on my point of order with respect to the validity of the notices of meeting? And I can refer to the procedural manual, but we didn't have 48 hours. It's clear that we can't hold a meeting tomorrow. I can't stay awake hour after hour. It's out of courtesy. It's not an act per se. It's not the legislation. It's not a guideline or instruction for the chair of a committee. I'll send it to you then. Thank you, Madam Chair. If you have something else, we can discuss it after.
Oh, I
Please,
don't
Madam
know.
Chair.
Ask Mr. Moore if he will let you go before him.
Well, you're ultimately the chair. I'm sure Mr. Moore won't mind.
No,
but you are,
listen, I don't want to get between you two. So please, the floor is yours.
I can keep him at bay.
he's got a mean left hook, Madam Chair, but I'm up to the challenge. I guess my question is this. I get that everybody wants, we all have an interest in C40, and we've all heard capable witnesses, and we have department officials. I understand that. The minister was set to be here on the estimates. That itself is also quite serious. So what I'm asking is why we don't have the minister here. And secondly, was there any consultation that was undertaken in that circumstance? Because I certainly didn't get consulted on that. You can.
So do you want me to respond now?
You're welcome to. I would prefer to just have a dialogue.
Why the minister's not here? I've already replied to that. I have nothing more to add.
Well, with respect, you said that we had to go on to C40.
We hadn't concluded C40, so we had to. That's correct. Conclude that first.
So your view was that you mentioned at least 3 times that the Conservatives had a lot to say. That's fine, but the minister also has a lot to say, and we also have questions for the minister on behalf of Canadians. So my question again is, why was C40 put ahead of the minister? And what consultations were made in making that decision in your capacity as chair?
The consultations that were made were my consultation looking at the schedule and at the meetings that we have and what witnesses we have arranged and what order of things I have to have finished. I need to have Bill C40 concluded before I go to any other to anything else. Because that had been agreed to before by everyone.
Okay, I'm sorry. So as chair, if I understand you correctly, Madam Chair, your position was that the committee had said we will not be dealing with anything, including the minister, until C40 is done. Is that your position?
That's absolutely correct, yes.
Okay, and maybe my colleagues can help me out. I don't recall us saying that we would preempt the minister as well on that. I don't know, was there an agreement to that? I'm asking you,
Mr.
Madam
Caputo, that
Chair.
was the reason we scheduled both Bill 321, which I reported on yesterday, clause by clause, successfully concluded from this committee, and Bill C-40. Those two needed to be dealt with and were on the order of business to be concluded. The minister's availability and his appearances didn't make any difference as to which date he appeared because what was the rule that as long as he appears, and I'm sure he's still willing to appear. So if we can continue with our business, do what we need to do, I am sure we can call him again to appear.
When does he have to appear by, can I ask? I don't know the rule on that. For supplemental estimates.
That's over and done with. That would have been a week ago, I think.
Point of order,
Okay.
Madam Chair.
Mr. Clerk? Yes, there was a motion at the latest December 7th. That's correct.
That the minister appear?
That's correct. And the minister had agreed to appear. The minister was scheduled to appear. There was no issue there. The issue was we did not get to any business. We actually did absolutely no business that was scheduled to be done
I'm aware.
last meeting.
I'm aware of that. My question is there a time by which the minister must appear based on our motion and based on reporting on supplemental estimates?
The supplementary estimate reporting is concluded. No, the time is expired a few days ago. I'll get someone
ahead of
to
me.
explain that to you, but that is in fact.
I'm happy, if Mr. Maloney can
Mr.
elucidate,
Maloney.
I'm happy to cede my questions there.
Sure. Well, I don't know. Maybe I can shed some light on this. Look,
Please do.
We all know why we're continuing C-40 today. I agree with everything Mr. Brock said earlier, and I've lived by that code my entire life. I don't know that it was necessary to bring Mr. Garrison into this, when it was a comment made off the record, but be that as it may. Look, we want to get all of these things done, and we want to get all of these things done as quickly as possible. There's been a number of points of order raised. The chair has ruled on them. I suggest the easiest way to move forward and address all of these issues, be it C-40 or bringing the minister back at another time, or dealing with the meeting tomorrow, which can be avoided if we get C-40 done today, by the way. I suggest we get to the matters at hand and then get through it as quickly as we possibly can today. There isn't that many amendments that have been put forward, and if we deal with them, another thing I like to do when I was practicing Mr. Brock was be as brief and get to the point as quickly as possible. I always found the adjudicators were very grateful for that. And I think if we can apply that practice here today, we can accomplish all of the things that we've raised as concerns today. So I suggest, Madam Chair, that given that you've ruled on the points of order already raised, that we move on and start dealing with clause by clause in C-40.
Mr. Garrison.
Thank you, Madam Chair. I'd like to apologize to the committee for my outburst and provide just a little bit of context. I just come from the House where I was asking a question very important to me on hate crimes against the gay community, where I was heckled by a member of the Conservative Party with, what about the Jews? I found that extremely troubling. And so people will know around this table that I am among the most collegial and among the most respectful in peace. I think that's my reputation. I'm not a heckler in the House. So that was what was behind that. But I also want to say that respect also means respect for the work of the committee and not bringing other agendas, other political agendas from outside this committee in to frustrate the work of the committee. And when that happens, it frustrates me greatly. The bill we have in front of us, C-40, Indigenous people and racialized people, but in particular Indigenous women, have been waiting for years for a better way to challenge the miscarriage of justice that took place in this country. And when we have heard from all the parties that they are in principle in favor of this bill, it's very frustrating for some members of the committee to prevent us from getting to the work of the committee. So I am frustrated. I will admit that. I don't believe I'm being disrespectful by being frustrated with not being able to make progress on a bill we all agree on. So I, too, hope that we could move through this today. I'm prepared to stay here as long as it takes, obviously, to do this. But that wouldn't be about the injustices that people have suffered in our justice system. That would be about another political agenda, and that's what I find frustrating. Thank you.
Point of order, Madam Chair.
Yes, Mr. Brown.
I want to thank Mr. Garrison for that, and I apologize to you as well, sir, if you in any way took my comments the wrong way. I wasn't aware of what you experienced in the House, so I do apologize for that. So I'm really confused, Chair. I know ministerial time is very precious. I know that I have been frustrated in my abilities to speak with various ministers for the last 2 years, so we always look for opportunities to have ministers appear at committee. We agreed, I believe, as a committee, if not at the subcommittee level, to have Minister Varani to appear on or before today's date, December the 7th. Obviously, a unilateral decision without consultation with committee members was made, which bypassed his appearance. I'm confused as to why C40 and clause by clause has taken priority over the minister when we probably agreed at the subcommittee level that both should be a priority for this committee. And I want to draw everyone's attention to the first page of Bill C40 that I copied off the computer earlier today. There's a recommendation under Bill C40 that says as follows: Her Excellency the Governor General recommends to the House of Commons the appropriation of public revenue under the circumstances, in the manner and for the purpose set out in a measure entitled an act to amend the criminal code, to make consequential amendments to other acts, and to repeal a regulation. This requires the allocation of taxpayer money. And the allocation of taxpayer money is at the root of what supplementary estimate appearances and discussions flow from. So Again, I could be the only one that's confused on this issue, and if I am, I apologize. But I thought, given the circumstances and given the recommendation in this particular bill, as in other bills, where there's an allocation of taxpayer money, that a priority should be given to the minister. So that concerns me. What also concerns me, Madam Chair, is your statement that the supplementary estimate process has been completed without any input from any committee member at the justice level. So I'd like to know how that happened, because I had a number of questions to Minister Varani on the allocation of money for Bill C40, amongst other issues in relation to the content of Bill C40 clause by clause. And I'm missing out on this opportunity. As I said, I've always had great difficulty, and I will throw a recommendation for consideration to Marco Mendicino, a colleague of ours, a former minister who always had an open door policy. I never had any difficulty speaking with former Minister Mendicino on any particular issue. I wish. Or now. And I wish, quite frankly, I wish all ministers of the Crown had that sort of mentality, because it certainly brokers mutual discussions on important areas. So in my view, I need clarification as to whether or not we've lost completely the ability to question Minister Varani on the supplementary estimates. Thank you.
There's a list, so you're all on it. Mr. Moore, were you still on, wanted to say something, or am I reminding you?
No, thank you.
Okay.
Thank you, Madam Chair. And you know,
Followed by Mr. Housefather.
look, I think Canadians would like to know why the minister is not here. Not to go belabor the point, but violent crime is up 39% the last 8 years. Gang homicides are up 108%. Gun crimes are up 101%. That's all in the last 8 years. So we have an accountability mechanism here whereby the minister appears. We made a decision as a committee that the minister would appear today. And initially it was going to be for 2 hours. Then that was reduced to an hour. And now it is no time at all. And that decision was made unilaterally. And I think we we need to revisit that, Madam Chair, and we do need to have the minister appear here. It's our job to hold government accountable for these and other things, and it's the minister's job to appear before us. So, Madam Chair, Mr. Brock actually covered quite a bit of what I was going to say, believe it or not. We debate our agenda, we make decisions, usually on a consensus basis. I had moved the motion that the minister appear. There's nothing out of the ordinary with that motion. Every committee would have a similar motion that a minister appear on the supplementary estimates. We agreed. There wasn't much debate at the time. I recall there was pretty quick agreement that the minister would appear no later than December 7th, today. So we also had the opportunity to deal with C40. We briefly dealt with C40 on Tuesday. We didn't get through it. It was slow going. However, we do have two more. It was very slow going, okay? It was very, very slow going on C40, but we do have next week to deal with it. So in my estimation, we never presume, we try to do best guess on how long something's going to take, but when it comes to clause by clause, I have often seen bills go over the course of an entire meeting or two meetings. I've seen clause by clause go 3 full meetings. And so in this case, I would have never presumed, oh, C40 on Tuesday, will be done C40, and then the minister on the 7th. The agreement that was made by this committee was that whatever happens on Tuesday, the minister is going to be here on the 7th today to be accountable. And so the minister has appeared in the past, should be here now, and I think that we do need to, on a go-forward basis, we have to look at when the committee makes a decision, and nothing, in my view, warranted a change in the schedule. I know a change in the schedule was made, and we've moved from scheduling the minister to C40, but I don't see what warranted that, particularly when we are here next week. Unless there's something happening that I don't know about, we're here next Tuesday and next Thursday. So on that point, Madam Chair, I'll leave it at that, but I do want to reiterate that in my experience, I think it's quite rare that a change in schedule would happen like that with such short notice, and B, to Mr. Fortin's point, the very short notice plan to meet all day tomorrow on Friday on C40. I'm sure that probably took a number of people by surprise. It certainly took me by surprise. I don't mind. I think there's a lot. I think C40 is interesting. It deals with a topic that our witnesses were extremely interesting, and I think there's a lot for us to flesh out. I think the government's proposal on C40 as it was drafted is wanting. I think we have amendments that we have put forward. There's other amendments that other parties have put forward to either to make changes to C40 as it was tabled, and we'll get to all that. But I think today we should have been dealing with the minister. And I guess my question, and I can't ask the witnesses this, Madam Chair, so I guess I would ask you is when do we expect to have the minister here on the supplementary estimates? Thank you.
Thank you, Mr. Moore. We're taking all these notes. Mr. Housefather.
Thank you, Madam Chair. I tend to be somebody, I think, like Mr. Garrison, who's collegial and tries to be pragmatic. I think most of us in this committee, fortunately, are that way. And so I want to first start by saying, because somebody made a comment about Jews, I want to just say that Randall Garrison has been the most solid ally that I have had in the NDP ever in standing up for the Jewish community in Canada, and I just want to put that on the record. Then secondly, on this issue, my understanding in committees that I've always been on is that clause by clause on bills supersedes other meetings. When you move to clause by clause on a bill, you continue clause by clause on a bill until you finish clause by clause on that bill. I thought there was an understanding, I personally thought there was clearly an understanding here at the end of the last meeting that we would then continue with clause by clause on Thursday. I thought that was fully understood. Certainly it was my full understanding. And the minister, I think I will answer Mr. Brock's question. The estimates, the deadline for the committee voting on the estimates passed before today. It doesn't mean you can't ask every question you want to the minister. We often entertain ministers after the deadline for that ends, but it would be no different if you had him today or next Tuesday on that question. So my recommendation is, since none of us, I think, want to be here tomorrow, is that we move through the clause by clause on this bill that is supposed to be on our agenda before we finish today. There are only 5 amendments proposed. The Conservatives, with all the flaws in the bills that Mr. Moore mentioned, only proposed 1 amendment. So let's try to get through that. I think we can, if we really try. And then we will have the minister at the next meeting on Tuesday, and we don't have to worry about Friday meetings that may or may not be in order. Thank you.
Thank you very much, Mr. Housefather. Was there anyone else? Mr. Van Popta? Or no, sorry. Did you have a motion at the end of what you said?
Go back to clause by clause.
That's what I thought I heard. That's
I
what
thought that was clear. That if you want me to make it as a motion, Madam Chair, I thought you had the authority just to do that. I move that we move to clause by clause now.
Well, yeah. Do you want to vote on it by a raise of hands, or do you want the clerk to call it?
I think, Madam Chair, you have the authority to tell the committee you started the meeting saying we were on clause by clause. I don't think we actually need a motion for this. I think you can move straight away. If I were the chair right now, I would move right away to clause by clause, and I would call clause 2, which is the clause we were debating in the previous meeting. And then we could have a debate and continue the debate that we were having on clause 2 with the speakers list that was there.
Sounds. I'm going to take that recommendation, Mr. Housefather, since you've been doing this for many years, and I am going to move on to clause 2.
Madam Chair, hold on a second,
Which
Madam
clause
Chair.
had I done already? We were on clause 2.
Madam Chair, on a point of order then, Mr. Housefather made a motion. I disagree with his motion, number 1, because we're obviously discussing things that are important to the committee right now on topic with what we were supposed to be talking about today. And I do want to point people's attention to the notice of motion that we passed. It was, and think of how this has been undermined with recent events. November 9th, 2023, the committee invite the Minister of Justice to appear for no fewer than 2 hours. There was consensus on that, no fewer than 2 hours. Regarding supplements...
I'm going to make a point. Mr. Housefather's motion was that we move to clause by clause, which, if I'm not mistaken, is a dilatory motion that does not allow for debate. We have to go right to a vote.
No.
Actually, that's what I've been told
Madam
here,
Chair,
yes.
a motion
We
to
have
adjourn.
to go for a vote.
A motion to adjourn, we would go to a vote?
Yes. Yes.
So motions aren't debatable now?
No. That's what I'm... Not this particular one, no. We will move to have a vote on the motion and then deal with whatever after
Are we
that.
going to debate the motion?
No, it's non-debatable. So, clerk, please go ahead. Do you want a recorded vote? Yes.
Well, what was the motion again?
The motion is that we proceed with clause by clause for C40.
He expanded upon it.
Mr. On the motion, Mr. Maloney,
Yes.
Madame Brière,
We,
oui. Mr. Mendicino,
Yes.
Mr. Housefather,
Yes.
Madame Dillon,
Yes.
Mr. Moore,
No.
Mr. Brock,
No.
Mr. Caputo,
Nope.
Mr. Van Popta,
No.
Mr. Fortin,
Oui.
Mr. Garrison. Yes. Okay. 7 nay, 4 nay, adopted.
motion adopted, thank you. We'll move to clause number 2. Just want to correct something before I go on there. I've got 2 members of Parliament virtually today who are both females, And so I'm not alone. And both have considerable legal and litigation experience. So I just want to ensure for the record that we have that on record.
Madame la Présidente, compte tenu la...
Given all of this, I did make a request, but I have observed that Ms. Briere has not got a proper headset on. Were the sound tests done and were they successful? You're nodding yes, but no, she can vote. She can vote without wearing a headset. She won't be intervening, but she can vote if she doesn't have a headset on. I don't understand what you mean. Say it in English, perhaps?
I'm going to take the floor, no. Elle ne parle, no.
Elle parlera pas.
Exactement.
She's not going to be talking. Thank you, Madam Chair.
Okay, so we're going to go with clause 2.
Point of order.
I love these, Mr.
know.
Caputo.
Points of order, do they just evaporate into the ether at this point? Neither of them were heard.
I thought I already answered them.
With all due
Okay,
respect,
okay, what is it
he
again
was,
you
he
want?
was speaking about the requirement in the motion that the minister appear.
Yes.
And why that didn't happen, because it was not a permissive motion, it was a mandatory motion that he had to appear by that date. And we didn't even hear what Mr. Van Plopta had to say on his point of order. So that's my point, is what happens? These people raise points of order and they weren't heard.
Madam Chair, I did, on my point of order, I do have a point of order. So, I'd like to raise it now as is proper. On the notice of motion, that the minister appear for no fewer than 2 hours regarding supplementary estimates, and that the meeting take place as soon as possible and no later than December 7th. So, it's December 7th. The minister
Sorry,
isn't
I'm
here.
going to interrupt again, Madam Chair. These, with all due respect, these points of order have all been spoken to, addressed, ruled on. We just voted. We just voted to move to clause by clause. So hearing from Mr. Moore or anybody else on issues that we've already gone over extensively today is out of order.
Well, Madam Chair, with all due respect to Mr. Maloney's comments, we don't have an answer to my point of order. The point of order, the question is when is the minister going to abide by the motion that we passed unanimously as a committee? This committee passed a motion that the minister be here today. The minister is not here today. My question, Madam Chair, is when is the minister going to be here? This is ignoring the will of this committee.
Modified notice of motion was sent to all members, clearly indicating we are doing clause C40. We will be issuing an invitation to the minister to appear as soon as this committee is able to arrive at a point where we can have someone appear.
Madam Chair, on that point of order, I have no doubt we will get there.
I hope so too.
But what was sent out is a notice of meeting. What we had was a unanimously passed motion. A motion supersedes a notice of meeting. So we did have a motion that all members, including government members, opposition members, we all agreed to have the minister here today. That was a motion passed by this committee, and the minister had agreed to be here. But the minister's not here. So I don't know why the minister's not here. I don't see anything that we're dealing with that would supersede our ability as parliamentarians, government and opposition, to hold the minister to account for his department that he is minister presiding over, and that's our role here. So you can understand how there's still an outstanding question of, in light of the fact, I acknowledge the facts. The facts are, we passed a motion that the minister be here today, right now. Fact number 2, the minister is not here. So the question that I'm asking by way of a point of order is, when's he going to be here?
We will let you know once we contact the minister's office, once we deal with Bill C-40.
Point of order, Madam Chair.
Yes,
Madam
please.
Chair, I believe I
So-
have the floor.
Oh,
Oh,
I'm sorry,
yeah.
my colleague, yes.
Yeah, no, so I've
Clerk, are you
I've been trying
keeping
to
order?
get in on this. It's really just a simple question, and that is, what is the statutory deadline for the minister to come and speak to us on estimates? Because I understand that there is a deadline, and I was surprised to hear, Madam Chair, that you say that that deadline has come and gone, and
With
I wonder why that
respect,
would
Madam
be.
Chair, these are arguments backing up the point of order. The point of order has been made clearly over and over and over again. It's for you to rule, which, in my opinion, you have already done quite clearly and unequivocally, and we should move on. Hearing further submissions in the form of argument in support of a point of order that's already been ruled on is completely out of line.
With point of order on that, he did not have the floor. My colleague had the floor. He was not recognized.
You weren't recognized,
I'd like-
you spoke out.
Suspend. Meeting back to order, please. So with respect to all the colleagues, there was a motion, we voted on it, and it is clear. We will now proceed with clause by clause C40. If you don't like what I've ruled on already and you wish to challenge the chair, please go ahead.
Is that like saying make my day? I'm not going to do it.
Can I get,
No more clarification. I have responded. I have responded to every single point of order. I will not take any points of order. I will now move to Bill C-40. If you don't like my decision, challenge it.
and that's what I want to get clarified, because you made several decisions, and I don't want to challenge several decisions, but I think the decision that you made, or from our perspective, did not make with respect to the question put to you by my colleague, Mr. Moore. I'm wondering if the chair wishes to reflect upon that. Before you suspended, Mr. Moore articulated the question again to the committee and to you, Madam Chair, and I believe he was requesting a response, and I could be completely mistaken on this, but I don't believe you ever ruled when the question was originally put to you and then clarified before we suspended. So again, I want to reserve my right to challenge whatever ruling you have. For the most part, I'm not in a position to challenge anything, but I think out of respect for Mr. Moore and for everybody at this committee, perhaps Madam Chair could reflect upon giving a reason or a ruling with respect to Mr. Moore's question. Thank you.
Which question was that? We could still invite the minister to appear next week if the minister is available. That is, clearly not and is not a problem or an issue.
Is he available next week?
Well, I'm sitting here right now. It's something that one can find out, so not a problem.
Can I just ask a quick question on that? Obviously, Madam Chair, or someone from your office communicated with the minister to inform him that because of circumstances, his presence was not required on today's date, notwithstanding our notice of motion compelling him to attend. Was there a further discussion as to his availability before the House rises before Christmas?
There was no discussion from the chair or from the clerk on that. The discussion was there was no discussion. What we understood in this committee, myself included and other members that have spoken,
So we don't-
obviously not yourself, that
Yeah.
we need to finish Bill C-40 before the minister appears.
I just want to be clear, so we don't know for a fact of Mr. Varani's, Minister Varani's ability to attend before we rise for Christmas break. At this juncture, that has not been confirmed, is that correct?
That is absolutely correct.
Thank you.
Okay.
I'm sorry, Madam Chair. I have a great deal of respect
Go
for you.
go ahead,
You're a
Mr.
great chair.
Van Popta, yes.
But you did not answer my question. What is the statutory deadline for the minister to appear?
Minister can appear at any point in time
is
that
a
the committee requests the minister, but in terms of the supplementary estimates, in order to go back to the House, I was told that was last Monday. The clerk can explain that, and I think Mr. Housefather already explained it. If that is not enough, I'm sure your staff can explain it as well.
I'm not so sure. So
Mr. Clerk, go ahead.
we have very good staff.
If you're really being honest and serious and you're not understanding, the clerk will explain. That's not a problem. We're happy to do
What is the
that.
statutory deadline, and what are the consequences of us having missed it?
There's no consequences that I'm aware of. Go ahead, Mr. Clerk.
Madam
Mr.
Chair.
Moore would know.
On the supplementary estimates, B, the last sitting, the last supply day is today. We have to count backwards on this for the limit in time for the committee to report the supplementary estimates B. So it would have been last Monday at routine proceedings, of course. So that's the time frame that we have according to, I believe it's 81.5, the staying order. I'm not too sure, but that's probably around that. Secondly, once that, since we don't know what's the last supply, they will be ahead of time. It's difficult to establish or to have a date where we are absolutely sure we can report to the House. Given that, the thing is that we can always have a study on the supplementary estimates on the subject matter. The difference between the subject matter study and the one under 81.5 is that we cannot vote anymore on each and every credit because they have been deemed reported to the House.
Just for clarification, I'm not trying to be difficult. I'm just
I
trying to understand.
I understand, yes.
The consequences are that that of having missed the deadline is that this committee is deemed to have approved the supplements.
Reported without amendments. Let's put it that way. But
It would be the same in each and every committee, obviously, yeah. And
why
I
we missed
believe it's
deadline.
the opposition that decides. Again, I've only come since September 2021, so this is different than provincial, but it's the opposition that decides what the last day is of the opposition day. So, you know, that was decided that it's today, so then we wouldn't have known that, and then you count backwards. But in any case, it's not within the purview of the chair of a committee, those dates.
This is your purview to have changed the meeting agenda.
Yes, that's right. That is part of my administrative duty as the chair, and it was done on the basis of the understanding that we had that we need to deal with Bill C-40 and not get any other witnesses. Would you like to proceed, or do you have orders that you don't want to deal with Bill C-40?
I think we're ready to proceed, but can we just verify who's on the speaking list as of now?
Nobody. What speaking list? No one, that's it. There's no one else on the speaking list. Can you help me? All right, so there are no amendments for Clause 2.
Madam Chair, on Clause 2.
Yes, go ahead, Mr. Moore.
So, Bill C-40 on Clause 2, the analysts are here, and they were here for 2 hours last, or the witnesses from the department were here 2 hours on Tuesday, so we appreciate you being here. And could you explain, there's not that many clauses in this bill, there's not that many amendments to the bill, but this bill is a massive shift, I would argue, from the status quo, the creation of a new commission, the moving away some of the discretion that it has been held in Canada in the office of the Minister of Justice. We have a history in Canada with those that have been wrongfully convicted. We've had miscarriages of justice. We also have a justice system that others in the developing world have looked at to emulate. So we certainly have a lot of good to work with. We have to be careful when we make changes. I know when we were in government, we made changes to the criminal code to improve the criminal code so that victims were protected, for example. The concern I have with Bill C-40, this has come up in the course of our witness testimony, and this is specific to Clause 2, but there seems to be, we heard from the UK experience. We also heard from, what was it, North Carolina? North Carolina. I found the testimony of the witness from North Carolina very interesting because she explained to us that factual innocence underpins their system. And that factual innocence, the reason I want to speak quickly to that is what most Canadians would understand a miscarriage of justice to be, meaning that, or particularly wrongful conviction, meaning that someone was arrested, charged for a crime, that they did not commit, that they were exonerated sometime afterwards, that there was indeed a miscarriage of justice. They were convicted for something they did not do. They've been wronged. The system failed them. And the actual perpetrator of the crime is somewhere out there and needs to be caught. That is what I think a lot of Canadians, when they hear about wrongful conviction or miscarriage of justice, that is what they imagine. My concern is that this bill goes significantly beyond what those Canadians would imagine and is trying to address with a broad stroke some issues within the justice system that could be addressed, but not in a way that undermines our system, creates a parallel justice system. There's a danger of that. And as we look, I don't want to get ahead of myself, but as we look down the road at some of the amendments that are being proposed on C-40, there's a significant broadening of the role of this commission, because underpinning even C-40 itself, as it was originally presented to this committee, was a requirement that a person had at least appealed their decision. With some of the amendments that are coming, we are almost creating a parallel system where if you feel you could be eligible by some factor for the wrongful conviction route, rather than appeal your decision, you would just claim that there was a miscarriage of justice and go this other route. That creates major concerns because we have a justice system that, at this very committee, in our study on the federal government's obligations to victims of crime, we had a witness who appeared, and many of you will remember her, and she said, and it left an impact with me, and you've probably heard me say it before, she said, "We do not have a justice system in Canada." She was a victim of crime. She said, "We do not have a justice system in Canada. We have a legal system." And in her mind, those were two different things. She had been through our legal system. She had been victimized, number one, but then going through the system, she felt she had been re-victimized. We have to be absolutely on guard with Bill C-40 that nothing we do would add to that sense of re-victimization for victims of crime in this country. They already have it tough enough. We've already studied and we've heard from them about how whether it's going to parole hearings re-victimizes them. The way they're treated by the system re-victimizes them. The fear they have appearing in court to provide testimony against the person that has committed a crime against them re-victimizes them. Victims of crime and their families are incredibly brave just to go through the process. And I know that to my left, a couple of gentlemen who've served as Crown prosecutors and have had to work with victims as they navigate the system and seek justice. And how many individuals, at the end of the day, say, "I don't feel justice has been served"? Well, with Bill C-40, there's a real danger if we don't get it absolutely right that we're going to have more of those stories, not less. That individuals who have been rightfully arrested, charged, convicted, are going to avail themselves of this parallel system. This parallel system will involve further trauma to victims, which is why we have a threshold whereby commissions, whereby ministers, right now, we've seen examples of thresholds that would say that there's a reasonable likelihood that a miscarriage of justice occurred, that there's a strong possibility that a miscarriage of justice has occurred. Neither of those even come to the civil level of balance of probabilities, let alone the criminal level of beyond a reasonable doubt. But what's in this legislation, it says, and this goes to the root of the whole thing, that's why I'm mentioning it at the outset, is a requirement that a miscarriage of justice may have occurred. What kind of threshold is that? That threshold is embarrassingly low. Of course, in any given situation, something may or may not have occurred. That is not a reasonable threshold. It's not a threshold that's used in North Carolina. It's not a threshold that's used in the United Kingdom. And it's not even a threshold that's used in Canada. Our Minister of Justice has a threshold whereby he considers these miscarriages of justice, and the team within the Department of Justice considers them, and may have occurred falls far below that level. So those are some of the concerns I have at the outset as we look at Clause 2. I do want to ask our witnesses if they could walk us through Clause 2, how it amends the status quo, certainly where we're at now, and how Clause 2 frames what follows with Bill C-40.
Yes, thank you for that question, Mr. Moore.
My pleasure. So Clause 2, I was explaining the other day, deals with Section 679 of the Code. That is the bail pending appeal provision. It was a recommendation following the consultations that the Court of Appeals would be the better placed to hear applications for release while the Commission is considering an application or after it's made a referral back to the courts, that those applicants could make an application to the Court of Appeal instead of the Superior Courts of Criminal Jurisdictions. They've been doing that under the common law, though they've been applying the bail pending appeal test, so the same test that applies if someone is seeking a conviction appeal. So that's what Bill C-40 does. And
Thank you.
yeah.
Thank you for that. When you say the same,
Can I recognize your colleague, or he has his hand
well,
up?
I did. Yeah, if I could
Oh,
just
okay,
finish
yeah, go.
quickly.
Yes, go ahead, Mr. Moore.
That just raised another question. So, using the standard, there's been much discussion around the standard around bail. Bill C-48 amends the bail provisions for certain offenses. The Bill C-75 brought in a presumption that has involved individuals receiving bail that many would argue shouldn't. So is the test then identical to bail? And what do we make of moving this decision to the appellant court, which is removed from the facts of the case that would have been dealt with at trial? It's a level removed from that. Is there what was the counter argument, I guess, to just leaving it at the trial level?
Thank you, Mr. Moore. Madame Besner?
So I mentioned that this recommendation came out of the consultations that occurred. The two retired judges who were responsible for conducting the consultations consulted with around 200 individuals and organizations. And this is something that came out of those consultations. There was quite a bit of support and not too much opposition to it. I could say that you asked the question about how would it apply before a court of appeal. A notice would have to be provided and an application put forward. It tends to be a quite extensive inquiry into whether someone could or should be released. I can also specify that it's the applicant that has to establish that the miscarriage of justice application is not frivolous. They would have to also satisfy the Court of Appeal that they would surrender into custody when required and that the detention is not necessarily in the public interest. So it's an applicant onus. And
okay, I don't want to get ahead of myself on this because we have other provisions, but we're dealing with, we have amendments coming up that would take away the requirement that is contained in Bill C-40 that the applicant have appealed the decision. So this is why it's important to back here on Clause 2. someone convicted of an offense, they've gone before a judge, they've been found guilty, convicted, they're left with a possible decision at that point in consultation with their lawyer, whether to appeal their decision or not, or whether to apply under the provisions of C-40 to the commission for a hearing that that they meet the threshold of wrongful conviction or miscarriage of justice. The threshold that we contemplate setting is a miscarriage of justice may have occurred. These are decisions that are going to have to be made by individuals. Now, under the current C-40 as presented, there would be no decision. That you can't avail yourself of the commission unless you've appealed the decision. But how do we reconcile this shift, or does it have to be reconciled with if we make a subsequent amendment that removes the requirement to appeal? We hear evidence all the time about delays in the justice system. We have the Jordan principle. We're taking court of appeal time potentially to deal with these miscarriages of justice cases. All the evidence we've seen so far is that the applications are going to go up. Some of the evidence we've seen is that our applications are going to skyrocket. I don't know that Canadians believe that there should be a skyrocketing in the number of people who are alleging that they were wrongfully convicted. But how do we reconcile? I guess it's not fair to you really, because we haven't dealt with that clause yet. But these two there's an interplay between the two. That the Court of Appeal is going to be in a position to have the hearing on release when someone has made application to the commission. Also could be the court that the decision is appealed to. And how does the interplay work on that? What if someone goes for a wrongful conviction application and then decides to appeal their decision? Can they? I don't want to get ahead because we haven't dealt with that clause yet, but the fact that one of the amendments came from the Liberals, the government, one of the amendments came from the NDP, I have a feeling this bill is going to be substantially changed, possibly removing the requirement that someone appeal their decision. So how do those two interact if that should happen?
So
Thank you,
Bill
Mr.
C-40
Moore. I guess, just having heard what you're saying, would you like us to vote on Clause 2 since there's no amendments and move to the clause that you're referring to? Would that make it easier for yourself and the committee?
I have questions.
Okay.
I want to truly understand Clause 2, and at this point...
Fair enough. So, Madame Besner, I think you were prepared to shed a bit more light on that. So, would you like her to respond, Mr. Moore, or would you like to have
I guess I would
more
like,
questions
if
first?
there's something to add, because this, if Ms. Besner has something to add based on what I asked.
Or maybe I can ask Mr. Van Popta. I know you've been patiently waiting. Perhaps you can also have your questions and what clarifications you need as well put on the table. So please,
awaiting
go
an
ahead.
answer to a very good question from my colleague. So I don't know if Ms. Besser wants to do that.
Just a suggestion, Madam
Yeah.
Chair. Maybe the two government officials can quickly jot down all the questions that I know my conservative colleagues will have, and then maybe suspend for a few minutes and then get all the responses all at the same time.
I think
that might be expeditious.
That's a tremendously good idea. I agree. So, Mr. Van Popta, absolutely. Mr. Van Popta, over to you.
Okay, so thank you so much, Madam Chair, and thank you, witnesses, for being here. So we're looking at Clause 2, which would amend Section 679.7 of the Criminal Code. I'm just going to read the first part of it, just to put it into a context. So Section 7, under 679 in the Criminal Code, would now read, if and when this bill passes, if the Miscarriage of Justice Review Commission established under Section 690 671 notifies the person under Section 696.4 that their application for review is admissible, then certain things happen. Sets off a sequence of events, and you've highlighted that. So thank you for that clarity on that. But my question is, what happens if the review commission decides that the application is not admissible? What happens? What avenues does the unhappy litigant, or I guess it's a convict still at that point, what avenue do they have under judicial review procedures? What's available? What's the standard for review? It's been a lot of years since I studied administrative law in law school, but I would just be curious as to what that is. I've studied something about the UK procedures, and I just want to be, do a comparative of that. So thank you so much for looking into that.
Mr. Brock?
Yes, thank you, Madam Chair. So, ladies, thank you very much for being here. As my colleague, Mr. Moore, has indicated, I'm a former Crown prosecutor. I did a fair number of appeals, very familiar with the process, and I know the language. I'm a firm believer, and I know my colleague, Mr. Caputo, is a firm believer in clarity when it comes to language in any piece of legislation, but particularly the criminal code, I think, demands clarity. And the concern that I have in Clause 2 is that it is not clear at all what the legal tests are being contemplated here. And if I understand correctly, and I believe the first question that was put to you, Ms. Besner, was to describe generally what this particular section means, and you gave us a response. Is it fair to say that this is purely a mechanism by which a convicted person who has received consideration from the review commission that the application that they have submitted is admissible, has an ability to seek release from whatever institution they may be at? Is that generally what Clause 2 is suggesting here? Okay, that's one question. So yeah, I'm going against my own suggestions here.
Okay, go ahead.
So I got more. So perhaps you could just jot down my questions. So, and again, the lack of clarity is this wording, where it's the third line in sub 7 of Clause 2. It says the section applies to the release or detention of that person, hyphen, as though that person were an appellant in an appeal prescribed in paragraph sub 1, sub A. So that is, in my opinion, extremely ambiguous in terms of the conferring of the rights attributable to the accused person, not the accused, the convicted person whose application has been ruled admissible. So I need to know why the drafters of Bill C-40 did not see fit to use the exact language that currently exists under Section 679, sub 7. And you, Ms. Besner, referred to it in terms of establishing that it is not frivolous. I believe you used that language, that it wasn't contrary to the public interest. And there was a third aspect, and I'm not sure what that third aspect was. I opened up my criminal code here. Just give me a moment. That he or she will surrender themselves into custody in accordance with the terms of the order. So the second question is, why wasn't that language clearly spelt out in Clause 2? Third question is in relation to the adjudicator of the release. In this particular case, the adjudicator would not be a judge, but rather, I believe, someone from the commission. I don't know if that is correct or if that's what's contemplated, but I would like to get that question answered. And I'm going to throw a hypothetical out to you as well. let's say, for instance, that the convicted person was convicted of a homicide, which generally attracts the most stringent of release conditions if someone qualifies in the circumstances. So I'd like to know, again, if all of the provisions currently under Section 679 sub 7 would be available to the adjudicator who is contemplating a release. The next question I have is, again, using the language in under the 679 of the code, where the first test is that the application or leave to appeal is not frivolous. My question to you is, isn't that rather moot, the whole concept of a frivolous application, in light of the fact that the commission itself has deemed the review to be admissible? So I wonder why the drafters of C40 would use duplicitous language, because clearly if the commission has ruled the application to be admissible, inherently they have ruled that the application is with merit and is not frivolous. But yet the frivolous test is still maintained under subsection 7. So I'd like to get clarity on that. I'd also like to get clarity in that hypothetical in terms of the availability of sureties, how they would present themselves, how would they give evidence to the adjudicator who's making that decision to continue the detention of the convicted person or the release of that convicted person. And again, I'm always very much concerned about inherent delay. And I know that the Jordan principles under the Supreme Court of Canada don't necessarily have the same rigid impact at the appellate level that they do at the trial level, the provincial or territorial level, or the Superior Court or Court of Queens, or Court of King's Bench, I should say, in terms of the prescribed timelines by which matters need to be completed. But I'm concerned about the inherent delay with this low threshold test, which in my view is going to increase the number of applications that are going to be presented to the commission. And I know that there's a future clause that we are going to study in terms of whether or not we're going to approve it. And the whole concept is to move these applications as expeditiously as possible. Again, not very clear language. So were the drafters of C40 contemplating something that was reviewable by the commission in terms of taking a look at the progress? I know the commission is mandated to inform the appellant along the way as to the status, which is not necessarily the case in a true appeal setting where someone is either on their own or with the assistance of legal counsel. But I'd like to get some clarity on that question. So thank you, Madam Chair.
You're welcome, Mr. Brock. I have Mr. Caputo followed by Mr. Garrison.
Thank you, Madam Chair. I don't sound nearly as smart as Mr. Brock, so I'll probably ask questions that may be a little bit, they might be a bit repetitive, but I'll probably ask them in my own way. One thing that is interesting to me here, and perhaps I'm wrong on this, but when we look at bail under the Court of Appeal, when somebody goes to the Court of Appeal, it's that court that issues process on bail, that fixes bail, as in it doesn't go back. They're convicted in Supreme Court or Court of King's Bench. It's not that court, it's the Court of Appeal. So in this instance, I'm assuming that then the Court of Appeal would fix bail on terms and conditions it sees fit, but it's doing it in respect of a process that it has absolutely no control over, because this is a parallel process as I understand it. Could there be issues arising by virtue of the fact that we have a court addressing bail, and then it's not a court, it's a tribunal of sorts, is addressing, or a commission is addressing the issue of wrongful conviction. Secondly, would it be helpful if there were enumerated considerations for bail when somebody is released on bail on the basis that their conviction is being investigated? And I believe that the threshold is the reasonable grounds to believe that a miscarriage of justice may have occurred. Because we haven't got to Clause 3 yet, as we know. Mr. Fortin is smiling. But that itself is going to be a very interesting question, is what does reasonable grounds to believe may have occurred, right? Because something a possibility of occurrence is one thing. I mean, that's why we talk about reasonable doubt and whether the doubt is a reasonable one. And then the reasonable grounds factors into that. Well, what's the threshold then? Because I think that an appellate court judge would probably want to know, like, look, how likely is this appeal? And if memory serves, I don't have my code on me, but if memory serves, there are actually matters within the code that an appellate judge can consider. Like, for instance, I believe like the likelihood of success on appeal. Now, at this point, too, we could look at the Court of Appeal, the distinction between the Court of Appeal, because they've only filed the appeal, right? So in this instance, they've actually surpassed an initial threshold. Sorry, do you want me to slow down? No? Okay. In this instance, I'll let you get your paper there.
Mr. Caputo, please address your questions through the chair.
May I let her get her notebook in order, please, Madam Chair? Well, I'm speaking to the witness, but I have to do it through you. So.
That's exactly correct.
So if I'm going to speak in any of it, I think you have my point. Through the chair, can I continue, please? Are the witnesses good? Okay. Sorry, I lost my train of thought. Imagine that.
From the top.
Would it be helpful if on a review for bail there were questions, or pardon me, like I think where I was going with, I believe that one of the things the court looks at is the likelihood of success on bail. And I don't know, to be candid, I don't know or recall what that likelihood of success is. I don't think it's a super high threshold. Is that something that we should be considering? It's, especially in the case of a life sentence, because and maybe when we deal with Clause 3, that informs it. How high is that reasonable grounds to believe that there should be bail? Now, because I'm not sure whether perhaps the witnesses may say, look, to the committee, look, this is actually a fairly low, this is a higher threshold than somebody on a court of appeal who has to satisfy the justice who's sitting as the bail judge. I'm not sure if that really could do it. Through the chair, am I making any sense on here? Okay. No? My colleagues say no. I believe, sorry, I may have one other question here. Sorry. I wondered, how about this? Would the duration of should the duration of the review factor into whether bail is offered? And by that I mean when something gets investigated, we don't know how long that's going to take. An appeal generally, though, is quite long. Probably truncated if somebody's in custody, but even if someone's in custody, it's often a few months to a year or two. So those are just a few questions, please. Thank you.
No. Thank you, Mr. Caputo. I'm now going to ask Mr. Garrison. to please
Thank you
ask
very
his
much, Madam
question.
Chair. I don't have questions for witnesses. I'd like to put a few things on the record here. One, I think it's important everyone understand that the same process of obstructing clause by clause is going on in 4 committees simultaneously. So I have a difficult time accepting the sincerity of members' questions at this point. Secondly, if members have questions about the wording of clauses, there's a process. And that process in this committee is to submit amendments. And the members chose not to submit amendments, and they're asking questions about the wording and saying it should be changed to something else. That process is submit your amendments. The Conservative members are also debating the threshold from which the commission can work. You have an amendment on that coming up. You did submit an amendment on that point. And so with respect, I would say we need to do that under the section that actually amends that clause. 2 more things that are more substantive. One is Mr. Moore raised the standard should be proving innocence. So in Canada, we have a Charter of Rights and Freedoms, which guarantees the presumption of innocence unless you're proven guilty beyond a reasonable doubt. And so inserting a clause that required proving innocence in this would be unconstitutional. In Canada, it's different from the United States legal regime, where a presumption of innocence is not entrenched in their constitution, but is a matter of case law and has limitations. And finally, there have been many references to the amendment that I put forward and that Mr. Housefather put forward as removing the requirement of exhausting appeals. Neither of the amendments does any such thing. They create an exemption where if the commission feels there were reasons that the person was unable to appeal, they would be allowed to take the application. So no one in this committee is suggesting that we do away with the requirement that people appeal before they can see the commission. So I just think that I would like people to be clear when they're talking about that no one made that amendment. There's no such amendment on the table.
Thank you, Mr. Garrison. Mr. Moore.
Thank you, Madam Chair. And I had a question, but I feel compelled just to respond quickly to what Mr. Garrison said. Number one, it mentions moving amendments. Conservatives did move an amendment. Some of my concerns stem from amendments that were moved by the NDP and by the Liberals. So we do not have those. When we're formulating our amendments, we didn't have the benefit of having those. So that's why I raised that question. What's happening at other committees, I don't know, but I do know this is the level of scrutiny that a bill of this magnitude should have. Like the idea that we would just blast through clause by clause on a bill that creates an entirely new commission, creates a different standard around miscarriage of justice, different recourse in the context of our justice system now and the delays that are in it. I think it is appropriate to ask those questions. When the last time departmental officials and the minister are here is when they're introducing the bill to us. We've just seen the bill, and the minister's here to present it to us. Now we've had the benefit of witness testimony, and we have some questions about what's actually in the bill. That's part of our job. So while in the past, I would say people have probably commented on some things longer than necessary. On this bill, I think these are all very valid questions. So I know that myself and Mr. Caputo and Mr. Brock have presented a number of questions to the departmental officials, and if we could get some answers on those, I'd appreciate it.
So thank you. I've just got some clear direction, and this is important. So I suggest we all listen, and if anybody wishes to challenge, please do so. We'll get legal here. No amendments have been moved yet on this clause. They are deemed confidential until they are actually moved, because a member can withdraw them. So discussion, I will not entertain any further discussion on any amendments until we get to amendments. And I didn't realize that. So thank you very much for pointing that out to me. I did want you to complete your sentence, but when that came to my attention, I felt obliged that I need to ensure that we're all aware of that rule.
Point of order, Madam Chair.
I don't know what point of order needs to be made on that. That is, but go ahead, Mr. Brock. We have a few minutes left, so.
Sure. I totally respect the information that you shared with us, Madam Chair, with the assistance of your legislative clerks. I think it makes abundance of sense, and I understand the position that you take, that you will not entertain any further questions from any member, given the lack of amendments to clause number 2. But at the very least, and I support Mr. Moore's commentary about the relevancy of all the questions that were put to government officials, I think we would be doing a disservice to Canadians and a disservice to this committee if we did not have those answers. So I'd be asking that the chair direct our government officials to respect your particular ruling, Madam Chair, but also to give us the responses to the number of questions, all relevant questions that were put to them. Thank you.
You're welcome. So, yes, you're allowed to ask questions, but you are not allowed to debate at all amendments that have not been moved. So we're going to terminate it at that. I'm going to leave it to the justice officials if you feel you've received questions that you are that you would like to respond to, not like to, but any clarification, I suppose. And let me just say this. As the chair of the committee here since September, but of course, having been on this committee for the last 2 years, I cannot agree more with each and every one of you that's spoken in the beginning, Mr. Brock, Mr. Moore, like all of you. This has been the most cordial and respectful committee, and it should be, because it is the Justice and Human Rights Committee, and if this is not, then what do we leave for others? So for that, I really want to thank each and every one of you, because I believe you are all here for the right reasons, and we are all doing our best to respect each other, recognizing that we don't need to, or we don't agree with each other's points, and that's fair, correct? Now, let me move on to the witnesses that are in front of us. I want to thank you on behalf of all the members that are here on this committee, because you have come today, you have come before today, you will likely come back tomorrow, maybe next week as well. But thank you for your patience, for your courtesy, and for your professionalism in dealing with each and every member on the committee as you clarify and do the best job that I know you're here to do for Canadians. So thank you very much for that. I'll now let you respond to, with the time that we have left, I guess, to the questions that were raised. That you can. The floor is yours.
Thank you. On the first question, Bill C-40 proposes that the requirement to have exhausted rights of appeal be maintained. There are exceptions that are laid out with respect to if an appeal was sought subsequently to the Supreme Court of Canada, and as I understand it, that's all that's being considered and proposed at this time on that question. With respect to what if the Commission does not consider an application to be admissible, yes, an applicant could seek judicial review of that decision based on, it would be reviewable on the standard of reasonableness in the federal court following an extensive body of case law that was recently updated in Vavilov, so all that law would apply. With respect to, it's unclear which legal test would apply for bail pending review. So Section 679 of the Code operates as its own, like it's a section. So all the subsections within the section apply. So in subsection 7 that's being amended, there's a cross-reference to Section 1A. And Section 1A is a conviction appeal that then references what the test is, and that's set out in 3, in subsection 3. So I mentioned earlier that the applicant would have to establish that their miscarriage of justice application is not frivolous, that they would surrender into custody when required, and that detention is not necessarily necessary in the public interest. With respect to the public interest, the case law has evolved quite a bit there, and it essentially has two components. It has a public safety component, and it also has a component that deals with confidence in the administration of justice, and the courts of appeal apply that. They also apply that the higher the seriousness the offense is and the lower the strength an appeal is, the higher the public confidence would be undermined if the applicant were released. And on the flip side of that, the lower the serious an offense is and the higher the strength of an appeal is, the higher the public confidence would be undermined if the person were detained. So the courts of appeal, that is the body of case law that they apply, and this would apply as well in this context, because an applicant would be treated just as someone who is appealing their conviction. A single judge of the Court of Appeal could hear the application. The notice that has to be provided varies in each different Court of Appeal because they set their own procedures for notice that has to be provided before a hearing will be scheduled. So this bill doesn't change that. You'll have to give me time there to go down the list.
Take as much time as you need.
With respect to a proposed release plan, consideration of sureties and other conditions, it would apply as it would otherwise in the Court of Appeal. All that is, it's just the standard that would apply as if it were a conviction appeal. So the considerations, I just outlined them. I think those. Did I miss anything? There's a hypothetical.
There was one of my questions I'm sorry. Oh, I'm sorry. I thought they were.
No, they're still conferring there.
Hypothetical about if someone has been convicted of a homicide, if that's the nature of the review that will be undertaken. I outlined a moment ago, the more serious the offense is, and if the strength of the appeal is low and the seriousness of the offense is high, then the Court of Appeal would look at how great would the public's confidence be undermined if that person is released. I can also say that there have been several cases that have been considered currently by the superior courts when the minister is entertaining an application for review. So there is a body of case law that has applied, and I could follow up if you would like, for example, a list of those decisions. It's well established throughout the country.
Thank you. Madam Besner, yes.
I think there was one question I don't think I received a response to, and that was, Madam Chair, through you, it was in relation to the term to proceed as expeditiously as possible. And the question I put to the officials were, does this new process contemplate the Jordan guidelines? And I prefaced it by saying generally the appellate route does not follow to a T the Jordan guidelines, but again, seeking clarity with language as expeditiously as possible does not really set out any finite timeline, and I was just concerned about that. I needed some clarity on that issue.
Ms. Besner, if there's anything you'd like to comment on that.
Well, you can elaborate when I'm done. So there's no specific incorporation of the Jordan principles specifically. There's the overarching requirement that the Commission must deal with applications as expeditiously as possible and to provide notices and regular status updates to applicants. it's been one of the main observations that the existing regime has been very lengthy, averaging often minimum a year up to 6 years, whereas in other countries they're able to resolve and consider applications in around a year. For the UK and in Scotland, I think they're able to do it in around 7 months. And so it's certainly one of the main goals of the legislation to be able to process applications more quickly. And the means to accomplish that is by having a greater number of decision makers. I think you all know that one Minister of Justice has many different priorities under that portfolio, and it's the only decision maker here. So with the Commission, with minimum of 5 up to 9 commissioners, with quite a bit more staff, the intention is that they're going to have a greater capacity to handle applications more quickly, so that people can have their matter referred back to the courts if it meets the referral test.
Thank you. So I'm going to call, shall Clause 2 carry? Well, I didn't see there were any other hands. Okay, Mr. Van Popta, go ahead.
We made eye contact, so. Good. I'd like to thank Ms. Bessemer for a very concise answer to my simple question about judicial review. And I wonder if she could give us 2 references. Number one, the section number in either C40 or somewhere else in the criminal code that says what the judicial review process is. And number 2, I think you referred to a case, and I just didn't get the name of it. So I would like those 2 things. Where do I look for the actual judicial review? What triggers it? And number 2, what's the case that you referred to?
I referred to the case of Vavilov, and the statute is the Federal Court of Canada Act.
Okay.
Is the body that will consider judicial review of federal administrative tribunals and bodies and commissions.
Right, good. And the name of the case again?
Vavilov.
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 Is that the new maker? Thank you.
Is Vavilov, I remember when I went through school, I didn't take administrative law, confession. Is Vavilov, akin to what Baker was a number of years ago?
I'm not familiar with Baker, but it's relatively recent. The Supreme Court, it was a federal court decision, and then it went to the Supreme Court in 2019.
Oh, okay. Well,
yeah.
That shows you what I know,
and
which is little. Sorry, Mr. Maloney is going to go read it tonight, so that's great. On the question of judicial review, theoretically, if somebody was to, if they sought bail pending review, if they sought bail pending review by the Commission, and then whether or not they got bail, but then subsequently the Commission ultimately denied that a miscarriage of justice had occurred. I don't know if or it just didn't go in their favor. I think you probably know what I mean. It didn't, their application wasn't successful, and they apply for judicial review. Could they then apply for bail in the same circumstances? That's.
I don't think they could because of the way it's proposed in the bill for what the trigger would be to make an application to the Court of Appeal for bail. So judicial review is not referenced.
Oh,
so I think
because it's not
the
expressly
Commission has to first
contemplated.
determine that the application is admissible and provide a notice, and that creates the trigger to be able to apply for bail pending.
That's a very good answer,
And okay.
because I never would have thought of that.
Well, I'm going to ask for unanimous consent to continue past the bells. We've got another 15 minutes.
I'm sorry, Madam Chair, we can't give consent.
You cannot give consent, Mr. Brock? Why not?
Sorry. I said sorry.
I was
didn't
prepared to say
sorry.
thumbs up.
You did.
did.
Listen, I respect your apology. Thank you.
you.
Well, colleagues, I guess with no unanimous consent, I wish you luck voting tonight. And I look forward to seeing you tomorrow morning. We will have coffee and tea. Please bring your muffins.
Has had a beautiful bacon, eggs, hash
Bring
browns.
your items, and I will see what I can do.
Yes, wonderful.
makes like a mean hollandaise sauce.
Yes.
How about I pair with you?
Oops, excuse me. Meeting adjourned.